So for those of you that don't know me, I'm Riley Palmer, one of the lawyers at Watson Palmer Law. I also moonlight as a bartending lawyer.
You do.
And further to Cindy Watson's speech yesterday, part of planning for the future is educating ourselves to better prepare for that future. At Watson Palmer Labor Lawyers, we've created personalized training courses and seminars. So what does this mean? So we have one course. It's dedicated to training from the point of a meeting and investigating that potential griever. Like, do we have a grievance here or not? Is this just a complaint or not? What do we need to do here? So it's training those members as well as the representatives to kind of identify that. Then we move on and we move through the investigation stage. So you're sitting there with a mock court, mock employers digging their heels in, not giving you the information you need, which is commonplace. And we're training our stewards and our members and even executive board members to pull that information out of them, to start building our case, to figure out, do we have an argument here? All starting before we're involving legal whatsoever, you're gathering all that information. And finally, we get to the step process. So it's the step 3, the step 4, the last step of your local. Typically, the top executive board member will be arguing those, but we let the stewards do it. We let the members do it. So put together those legal arguments that you've heard over and over and over. Look through your collective agreement. Are there procedural arguments? Can you find them? Can you put them together? Can you articulate them? So getting everybody familiar with it, there's no rights that are going to be missed here, right? The course is practice scenarios. So it's essentially, I think we have like 10 or 12 different scenarios, and they're all based on real life cases. We want to have a balance. We want the wins and we want the loses. Why do you want to know the losses, right? We need those losses to understand what went wrong. Was it the witness not being credible? Was it procedural arguments that we lost or forgot to argue? And we get to see how arbitrators, weigh those, the kind of the pros and cons and how they make those final decisions. So it's fun. It's like, we'll give you cases that arguably are loser cases. And if you end up winning it, fantastic. You did better than the lawyers. We also offer courses dedicated to breaking down and understanding the legalese in the contract language, minutes of settlement language, with the idea that we have this language, it's complicated, it's legal jargon, we break it all down, but we don't leave you there. We then build those members back up. How do we use this? How do you use it without having to involve the lawyers to a degree, right? If there's template language just to understand it, we could put it in there. We can identify issues in minutes of settlement where, this will actually do some harm potentially. So keep an eye out for that. So it helps them take it, break it down, build it back up, just so everybody's better educated and they understand the process. I think this is particularly helpful for smaller locals who can't afford to have a lawyer, on retainer and they're calling constantly. In addition to that, you can check our website. We offer training on duty to accommodate, media training, workplace safety training, note-taking training, and negotiations training.